Ennoble IP, a globally renowned IP attorney with over 20 years of experience. Featured in IAM Patent 1000, Dr. Singh has been honored by Prime Minister Shri Narendra Modi and NITI Aayog. She specializes in IP across sectors and has received multiple accolades, including Inspiring Women Leaders Under 40. Welcome, ma'am. Our second speaker is Mr. Himanshu Chawla from K&S Partners, lead IP advisor to over 20 tech corporations, specializing in patent drafting and prosecution in electronics, communication, and computer engineering. He holds a BTech, LLB, and expertise in areas such as 4G, 5G communication, and machine learning. Welcome, sir. Our third speaker is Mr. Hiroyuki Nakano, Senior Director, Intellectual Property Rights at JETRO, New Delhi. With a Master's in Engineering from Tohoku University and extensive experience at the Japan Patent Office, he specializes in IP examination, policy, and international cooperation, including research at the Imperial College of London. Welcome, sir. And last up, we have Mr. Sumer Riaz, IP author from Dolcera. He is a seasoned solution architect and general manager at IP author with 13 plus years in IP drafting, prosecution, and IP strategies. A pharmacy graduate with an MBA focusing on AI and legal tech innovations. Welcome, sir. Now I'd like to hand over the session to Mr. Garg Vyas, the impact of generative AI on traditional IP frameworks.
Hello, everyone. A very good evening. Thank you so much for inviting to this great, wonderful platform, GIPC. It's always knowledge-rich and always glad to meet variety of experts and to hear from them on the very latest topic on this platform. Really glad. So, generative AI and its impact on the traditional IP. Before we get into the impact of Gen AI into IP, I would like to highlight a recent World Intellectual Property Organization report which talks about the statistics on the number of IP, especially the patents filed in the area of AI and specifically Gen AI, which says in 2014, there were approximately 730 plus patents. And in comparison to that, in 2023, there are more than 14,000 patents have been filed in the area of AI, specifically Gen AI. From 700 something to 14,000 within a span of almost 10 years. If I talk about scientific literature, so scientific publication is also interesting. In the same time frame around 2014, it is around 110 or 110 plus. And in comparison to that, if we talk about 2023, it is approximately close to 35,000 scientific literatures have been filed in the area of Gen AI. So this many patents, this many scientific literature is obviously clear indication where the innovation is heading in this area. But the question is, the same technology which is crazily driving innovation, can it be used to improvise the same IP ecosystem? On that topic, I would like to start the discussion of this panel And first, I would like to come to Shweta on this particular topic. Shweta, before we even start, if you can, in a 1 minute or so, if you can talk how your organization or particularly you are, associated, or, how you're, correlated with Gen AI, what are you doing in this area? And then my question to you would be, if you have this much IP filing in the Gen AI area, if you have this much scientific literature, my question to you is how Gen AI itself can improve the IP ecosystem in terms of IP searches, IP or patent drafting, patent management, etc. Over to you.
Thank you so much, Garg. So basically, we support universities, corporates, and law firms for all their requirements. So we are not law firm, but kind of KP or IP boutiques where we support with the technical and the legal matters with to our clients. And how we are connected to artificial intelligence or Gen AI is like we are supporting lot many startups and universities wings who are working in this particular area. As you mentioned, the numbers exactly in last 7 to 8 years have almost 100x if you see. So that's the kind of amount of work being done in particular domain, not only in India, but UAE is a big market for AI and blockchain and these kind of technologies, and same is happening with Silicon Valley and Austin, Texas coming up in the same. So we support such kind of startups. When it comes to the opportunities, how IP firms can actually leverage this, personally, I am not a person who exactly 100% motivated with Gen AI or AI for IP firms. I'm kind of, and this is my personal opinion, that without human interference, without human interpretation, AI will not give you the exact result. So coming with the, because challenges, I think we will talk later, but how this is going to benefit is like the question you asked is about patent searching, drafting, and management. AI, every year we file million of patents, right? And for a human to analyze complete set of patent in a particular domain sometimes become a critical task. Going forward, no one can escape AI, but we should be better in a way adopted with human intelligence, which I believe and I convey to my people also, my team also. So basically, when you have to do a patent search, this much big data, where actually with the help of AI you can scrutinize and come up with a set of data where you can actually use your human intelligence to analyze that. So your time efficiency, you can manage your time. The work which you do in 24 hours can get reduced to 8 hours, 9 hours, right? So your team will be saving the time. But again, I am telling, AI cannot replace the human because it is run by human. For drafting and all, it is very simple that analyzing the set of, it can only provide you a template. Gen AI can only provide you a template. Also analyze the natural language of different jurisdiction where it is difficult for a person sitting in India to just analyze different language because everyone is not aware of different languages. So it can actually help in increasing the efficiency in claim drafting, specification drafting, and provide you a template where your team can actually reciprocate the kind of technical intelligence they have. Now with the competitive, it actually can help the team, especially the analytics team, with the strategic decision making for the businesses, because competitive intelligence is something where AI will play a major role and is playing a major role, because it can give the technological evolution, it can give you the competitive landscape and market analysis, where actually when a business has to take decision, it will be very, very streamlined and will help the decision makers seeing what is the competitive landscape of that business. Then it can help with the IP management, because your deadlines, your monitoring, the risk will be minimized in that sense. So overall, it will be a helping hand, not replacing the human, but it will be helping hand, increasing the efficiency and managing the time, I believe. Thank you.
Thank you so much, Dr. Shweta, on this. What I understood is definitely it cannot replace the human being, but it can help us saving lot of time in analyzing, scrutinizing a huge, big chunk of data. When it comes to drafting, what I understood is it can be useful in some way of, non-English or foreign translations and some other aspects, and definitely helpful as per your thoughts on the IP management. I would like to now go to Himanshu. Himanshu, you are, as a lawyer working on, patent drafting, prosecution, and some way the litigation also, I understand. My question directly to you is, do you agree? Is it that easy to use AI and analyzing this data, or use AI in patent drafting, use AI in the machine translation, and etc. for the foreign, or non-English literatures and etc. Moreover, do you also agree that such outcome in the form of drafting or prosecution using Gen AI can be accepted by the examiners and etc.? So I want to understand from you as a lawyer, what are some of the challenges or key considerations on this?
Thank you, Garg. So as Shweta indicated that AI has its own benefits of analyzing huge amount of data. But when we talk about searching, so the most important challenge what patent practitioners may see with respect to AI-generated prior arts is whether the AI-generated prior arts are enabled or not. For example, the AI may generate a reference related to a drug compound without any experimental data. Or, for example, it may come up with references of circuit layouts without explaining or defining the operational parameters or the instructions, the way a circuit has to operate. So it becomes important for patent practitioners to see whether the enablement threshold is met or not. Similarly, AI may generate prior arts from private databases, proprietary AI systems. So determining whether the references were available to the public at the relevant time is another challenge, what we see. AI may erode the effectiveness of blocking patents, which is a key strategy for companies to prevent the competitors from innovating in the same technical area. So AI may generate numerous alternatives and numerous alternatives which may bypass the existing patent claims and may even challenge the broad claims. Lastly, with respect to patent search, obviousness determination may also be more complicated. For example, if AI is used for drug discovery, it may come with millions of permutations, and the bar of proving that the new drug becomes very difficult, whether that the new drug is not obvious. Coming on to patent drafting, so although AI may reduce time, as Shweta indicated, and give us a draft in a much faster period of time, but I think it may lack certain nuances of patent drafting, which may include the relevant legal framework, the strategic foresight, and the deep understanding of the invention. So the drafts which may come up could be more generic, broad, and maybe sufficiently, they may not sufficiently disclose the technical information to withstand the standard of prosecution, rather in examination as well in litigation. Another point could be with respect to patent drafting, AI may not be able to fully give the scope of protection which the business needs, or specifically onto the points which are being infringed upon. And lastly, as we know, AI models may hallucinate, generating something which appears to be true on the surface, but they are not in the ground reality. And which may also lead to security concerns if some information goes out due to compromising of the AI programs. Yeah, thank you.
You scared me. You scared me. Are we here to talk about use and importance of Gen AI or something else? I don't know. Based on your talk, I feel we should not at all. Huh? Please raise hands who feel after hearing from Himanshu. We should not at all use Gen AI because it is more complicated as per your speech. Oh my God. Sumer, the lawyer has indicated a lot of challenges, ifs and buts, lot of concerns. So now, obviously, I'll come to you, Sumer. Is there any solution to this? Or we should simply go away without using Gen AI in the IP ecosystem? Because Himanshu said, if we use Gen AI, it will give multiple options. I have used ChatGPT for so many things in simple searches, and I can see draft version 1, 2, 3, and I don't know how many. And I can correlate with him. The broadness of the claim, I can somewhat correlate. When it comes to the drugs discovery, the multiple permutation combination, of course. And to be frank, I was very bad in my 12th chemistry, so I will not discuss further on that topic. But based on Himanshu's overview and the challenges, I feel it is more imperative not to use, or it is more challenging or more difficult to implement generative AI in the existing traditional IP framework. What are your views? Is it true, or what your views are something different on this?
Yeah, obviously, thank you. Indeed, whatever points that Himanshu raised are true. These are things that people have seen. But my point of view is slightly different, is that as you all know, AI and Gen AI, it's an evolutionary topic. We are learning a lot every day. There's a lot of evolution of this whole technology every week. And while these challenges have been seen, but there are also efforts put on by various technology providers, for example, the one I work for as well, towards mitigating these challenges. I'll speak about some of the things that Himanshu kindly commented upon. For example, talking about the risk of searching with AI, where the point he raised with respect to the use of private systems for training, and then for training the system, and therefore the answer of a search ended up being, let's say, an article that was not public at a time, right? So this is obviously something that some of you may have seen. The way we, at least, for example, have solved these challenges is that instead of relying only and solely on the training systems of AI models, which can also vary. For example, OpenAI models could be entirely different from Anthropic models and could be entirely different from Google's models, is to rely specifically on known databases which are public, which are reproducible, and use AI actually to retrieve answers from these databases. So the way we have overcome this challenge, and also, by the way, by effect of this, overcome the challenge of hallucination, because AI can also make up results when they don't exist, is by using generative AI models to frame questions. Because when AI hallucinates, the answers look so relevant, so true, which means that its understanding of what to look for or what exactly should be called relevant is good. You use it actually to detect this rather than to create it. So in the background, you parse the search query to a actual database which is reproducible, updated on a daily basis, and then ask AI to find the answer of what it calls as relevant from that, and then use that then to also disclose whether how relevant, how similar this is to the invention that you had in mind. Right? So the other point that Himanshu mentioned was with respect to the drafting point, which is that, yes, at the first outset, the demands of a patent attorney will not be met in relation to relevant legal frameworks, in relation to, for example, making sure that there are sufficient disclosures made, or generally the scope of protection. And these are all very customized, let's say, interpretations of a same invention in different jurisdiction, or by different attorneys maybe in the same jurisdiction. So how we should look at this perspective and take help from AI is the following way. Is if you look at AI not just as a generative tool, but also to prompt AI to influence the answer in a certain direction. Right? So you use AI, you understand what the first, let's call it a draft is, and then prompt AI in a direction in which you want it to actually reproduce the result in. Which means, let's say you found the first claim to be very broad. Garg also mentioned, we've seen ChatGPT creating broad claims, or sometimes very, very specific claims. The point of generative AI is not only the disclosure that it creates, but is also to adapt to your understanding. In that sense, what my employer, we have done is that we are looking at mimicking a conversation between an attorney and an associate. When you, as an attorney, give a certain patent draft to an associate, the first draft itself is not what you file. Or when a conversation happens between an attorney and basically or a client, the first draft itself doesn't get filed. There are conversations that happen, and the use of natural language interactions or prompts with AI help solve this challenge. Right? So the point now is we as IP professionals and obviously attorneys will also have to learn the language of prompting, and will have to learn the language of actually interacting with the AI. That's how we would solve these challenges. And we are obviously, as I said, this area is evolving rapidly, finding out more and more ways to overcome these challenges, and overall making the whole area more efficient. Because again, we are not trying to replace an attorney, we are trying to only create a much more efficient attorney, create or increase the throughput of attorneys to overall increase filings and IP activity in various jurisdictions. Thank you.
Thank you so much, Sumer. And this really gives me a lot of bringing back my confidence back in the Gen AI. Thank you for that. And I understand generative AI tools are producing high quality results, content across variety of mediums. Let it be patent drafting or even for prosecution. You mentioned, if we train it, adapt it, it can bring out the high quality results. Use of Gen AI also allows anyone to create many new designs, and they can be easily made public through nowadays variety of social medias like LinkedIn, Facebook, Twitter, etc. But I guess I have a question here, and I would like to ask this question to Mr. Nakano. When Gen AI is producing variety of new or novel designs, and if those designs which are new in the nature or novel in the nature, and if it is made public through social media platforms or some other way, what I feel is if it is made public, the applicant may lose novelty. One, because many forms of designs are created. The other is, it may be, made public through the social media and so. So how the genuine applicant may granted the rights? That is my question to you, Mr. Nakano.
Yes, thank you. So while we tend to focus on the advantages of generative AI, I dare to mention its disadvantage. Now, generative AI have several risks and for genuine applicants, just my opinion. In particular, now, I'd like to emphasize the examination of design applications. So for example, in some countries, including India, novelty and originality are required for registration of a design. Novelty means, of course, to be new. So this is a part of substantive examination. So on the other hand, the use of generative AI allows anyone to create many new designs. They can easily be made public through social media and other means. For example, when predicting the next model for a popular product, for example, the automobile or some phone, this can occur. So what happens in this case? So maybe an applicant seeking to use that design, I mean the genuine applicant, may lose novelty in examination procedure due to the many designs created by generative AI. So this situation discourages the filing of design applications and create an environment where genuine creators are not protected. So just my opinion, in some cases, some legal remedy such as an exception to lack of novelty may be necessary, I think. That's all.
Exception to the lack of novelty. This is what is your view. Well, that's a big area, and that's where I guess in such scenarios we may have to write it to the government, or government intervention may require, to the amendment into Act when the Gen AI can be used. And since now we have almost 15 minutes left, this brings to another round of discussion. Since you brought in the very important aspect of intervention of government, Sumer, you talked about use of AI and how it can be used, but then again, the examiners, are they able to use it or not? Himanshu, you already throw so many important challenges as a lawyer. So now let's talk about the aspect where the government, what role government has to play, the IP organizations, and etc. So on the second round of discussion, considering the sensitivity of time, I request all the speakers to, please provide your views on this within 2 to 3 minutes, please, so that we have some time at the end for the Q&A. But with that, I would like to come again back to Dr. Shweta. After hearing all this, what are your views, since you are associated with, not only the business, but also the universities and some of the government bodies, and you also got a recognition by our Prime Minister, Mr. Narendra Modi. So I want to understand from you, what will be the role of governments, IP organizations such as World Intellectual Property Organization and some other such organizations, businesses in shaping the future of IP in the age of Gen AI?
Thank you, Garg, for bringing this question, because this is like, as I mentioned, that we cannot escape AI right now, but we have to somehow play equitable role with the human intervention with the AI. And this is a big revolution, I would say, is happening right now in the technology. And when there is a revolution in some kind of technology, all the parties should come together and have dialogues. So according to me, when it comes to government, the policy formation should be very clear and implementation should be very clear. They should actually work on the model where Gen AI or AI plays a crucial role. They should define the roles and responsibility of AI either in the businesses or people using, developing the technology, or the firms like us using AI. Then when it comes to organizations like WIPO or similar organization, they should also play a crucial role, because they should be intervening with government, with the local jurisdiction, and coming on a platform where all local bodies, and when I say local, it's the different jurisdiction, laws, different countries' laws, talking about what they are talking about AI, and similarly what internationalization about the similar law and similar policy formation. And when it comes to businesses like us, who are actually supporting the tech platforms or tech startups or tech businesses by using different kind of AI tool, either in searching, drafting, IP management, or for making the strategic decision, I feel we should be very transparent what level and how we are using the technology. And also we should be accountable. Ethical accountability is one thing which businesses like us should be always very much transparent, not only to the clients, but with the government, and it should align with the policies or the reforms which government is making.
Sure, thank you so much, Dr. Shweta, on this. And definitely the government intervention or the IP organization intervention is must. I would like to now little bit switch here, the discussion with Mr. Nakano. Sumer, you talked about when it comes to Gen AI, lot of training is required to train the Gen AI to deliver the results which are more relevant in nature. Now, generative AI tools can only produce such quality relevant results when they are trained with the vast data sets. Now my question to you, Nakano, Mr. Nakano, is to train generative AI using such data sets, can the trademarks that are registered trademarks, designs, or copyrights, can this be considered to use as a data set to train generative AI?
Yes, thank you. So, as you mentioned, for the use of generative AI, it is necessary to provide the AI with a large amount of material and have it learn. And it is also necessary to consider whether this learning would constitute enforcement of intellectual property rights under Indian law. Okay. In Japan, normally it is considered that it doesn't constitute enforcement. It's just my opinion. This is just my opinion. That because they are not related to the specific service or specific product in terms of a trademark. So also, even if it does not constitute enforcement under IP law, some individuals may prohibit such use, maybe. So anyway, we need some discussion under Indian law. Also, we should act with caution, I think.
We should act with caution. That is your advice. We talked about trademarks, copyrights. We talked about designs. We talked about government interventions, etc. Little bit coming back to the patent side of it, and that brings me to the classic case of Dabus, the first AI invented patent accepted and filed in South Africa. Well, South Africa is the nation which accepted that, but when I gone through the US and European, draft laws and bills and some of the papers provided by the government of EU and USPTO and government of United States, I see contradiction in this. So Sumer, can you briefly summarize with respect to considering the US and European laws, the case of inventorship on the generative AI and some other related aspects?
Sure, thank you. I'm going to talk about the last guidelines from USPTO with respect to the use of Gen AI and briefly point out to the inventorship and then maybe let Himanshu talk about it in more detail. But I'll definitely talk about the USPTO guidance in the Gen AI and also the perspective from EU, which is the EU AI Act. There are about 5 points of consideration with respect to USPTO's guidelines that came last year. The first item that they discussed is about the use of AI in document analysis or document preparation. So there is indeed no prohibition on the use of Gen AI models with respect to any communication of any documents, let's say drafts or office action responses or even searches to the USPTO. However, all the attorneys using these tools, the onus is on them to make sure that the information given is accurate, right? And to that extent, that is the second point, and is that on each of these documents that are submitted to the USPTO, the attorney has to sign his or her name or their name on the document so as to create a validation of their consent of the information that they have supplied is correct to the best of their analysis. The third point is obviously with respect to their own protection, which is about the confidentiality. While using these tools, every practitioner or attorneys have to understand the confidentiality part of the tool that they are using. Whether this is an in-house tool or a third-party tool, understand the terms of use, understand the flow of data, understand the encryption, so as to make sure that there is no public disclosure later for all the information that you are talking about. The fourth item that USPTO mentioned is that no Gen AI, no model should communicate with the IT systems of the USPTO. It should always be an attorney who is himself or herself responsible for doing the communication. IT systems or bots should not communicate with USPTO IT systems. And the fifth point is about the patentability question. Obviously, some things have changed from the Alice Mayo days. USPTO now is slightly more open. Well, when I say open, I mean things are getting harmonized compared to what used to happen. What happens in the EU is that for all the AI inventions, you have to talk about the utility. You have to talk about how you are solving this problem, right? Which is common in the EU as well. Then coming to the EU, there the approach, per se speaking, there is no guidelines from the EPO on the use of Gen AI tools, but all of these considerations that I will talk about stem from the EU AI Act. The EU AI Act that came in a few years earlier has two major aspects to understand. The first aspect is risk understanding and definition of risk. And the second thing is transparency. So when it talks about risk understanding, you have to understand the AI system that you are working, is this merely a game which is less risk, or is it a social security or social scoring system which is high risk? And once you understand the risk, the onus is on you to make sure that you create a transparent information access. Talk about, for example, dealing with an AI tool internally with attorneys and with the EPO or all stakeholders, in this case, the EPO. The second thing is you have to understand how high the risk is for the use of your AI in the legal system. Will it create disclosures which might not be relevant? Again, onus is on you to check the information accuracy. The third point is explainability of AI tools. None of the AI tools have to be so-called black boxes. You have to understand yourself how AI works and therefore reproduce or explain your answers why a certain prior art result set ended up in my in my report or not? Why didn't the other one come? There should be reproducibility in that sense. The last item is obviously address misleading or wrong information, which interprets or correlates to the first point in the USPTO one as well, is that you are yourself responsible for all the answers, and make sure you read and make sure that you have sufficient analysis done on this item. And that's basically what the whole regulation or in that perspective guidelines are. But of course, Himanshu, if you want to talk about a bit before we wrap up about the inventorship point about that aspect as well.
So maybe in a 1 minute, if you can wrap up that.
Yeah. So as Garg indicated, the classic Davos case, so AI cannot be considered as an inventor. So USPTO has given some guidance that in AI-assisted inventions, a natural person can be named as an inventor if the natural person has significantly contributed to the development of the invention. And by significant contribution could be providing prompts, constructing detailed prompts, modifying the output, etc., or even modifying the output of the AI, rather curating the output of the AI, and like training the AI or designing the AI. So these are few possible examples of significant contribution. Thank you.
Thank you, Himanshu. And I guess the fake or the interpretation aspect, that brings me to the very recent backlash over Apple generated AI summary on the news article published by BBC, which is a very recent, and there was a huge backlash. The reason for the backlash is the Apple AI generated summary of the news article published by the BBC News was totally a wrong or a different interpretation to the news article subject line written by the BBC News article, and that was a very, very recent scenario. It is very interesting to read on that. I think we are almost running out of time. We can, address only one question, and after that we are available outside for any other question, answer, or a discussion. Thank you, everyone. Thank you so much, panel members, for your insightful, views on the impact of Gen AI on the traditional IP system. Thank you. Any one question? Otherwise, we can conclude. All right. Thank you, everyone.
Thank you all for that wonderful session on the impact of generative AI on traditional IP frameworks. I'd like to call upon Mr. Garg Vyas to felicitate our panel members. First, we'd like to start with Dr. Shweta Singh, founder of Ennoble IP. Next, Mr. Himanshu Chawla from K&S Partners. Our third speaker, Mr. Hiroyuki Nakano, Senior Director, Intellectual Property Rights at JETRO, New Delhi. And we also have Mr. Sumer Riaz, IP author from Dolcera. Mr. Garg Vyas, we shall hand over your memento after this session. I'd like to ask all the panel members to please pose for a group photo. Thank you all.